Okay, thanks everyone for joining us for today's presentation. I'm going to get started. There may still be a few people who are trying to get signed in, but hopefully that goes well for everyone. You should be able to see the cover slide for pay transparency in New York, legal requirements and related concerns. I am Scott Horton, owner and attorney with Horton Law PLLC. We are based in Orchard Park, New York, just outside of Buffalo, but have clients around the state of New York, and will be giving this update as a general uh, informational session for interested parties throughout New York State. Will not be providing legal advice, and that goes for the question and answers that will take place during the presentation as well. So while it's informational and it's certainly based on my legal experience, if you have a particular situation that you need detailed legal advice on, you can contact me separately or contact another labor and employment lawyer for that. If you have questions in this session, you can type them in the chat window and I will answer them probably at the end during question and answers. But if I happen to see the question at a point where I can work my answer into the presentation, I will do that. The slides for today's presentation will be made available at the end. So if you want them right away, you can hang on to at the end and get those. Otherwise, you will get an email tomorrow confirming your attendance with a link to the materials as well. With that, again, as long as you can hear my voice and see the slides, you should have access to chat where you can type in questions. Otherwise, if you're having any trouble with the quality of the feed, then I suggest you shut other apps or windows on your device, as they may be interfering with this. But if everything is going well for you, then I am glad you are here and we are going to get started. So today's topic discusses a few different aspects of legal requirements regarding pay disclosure or salary disclosure, compensation disclosure. There's different words that are out there. All of these you can interchange: pay, compensation, salary, wages, and you can interchange disclosure, transparency, and certain other words. But what we are talking about here, in some way, shape, or form, is how companies make the pay rates for their various jobs known to people who may be interested in those positions. So there are laws that are coming into place around the country, and we're going to talk about that in more detail in subsequent slides. But even without legal obligation, some employers have begun identifying at least the pay ranges, if not the precise amount of compensation for positions, such as when they post them looking for applicants to hire. Why would companies do this, and why would other companies choose not to if given the choice? Well, all of these pros and cons I've listed here with question marks, because I don't know that there's any guarantee that any of these are true for every particular organization out there, but they are factors that are being considered by some or many. Some of the pros include appealing to applicants. So there is the idea that by explaining specifically what the job will pay, you are more likely to attract the candidate that you want for the position. You may not get applications from individuals who either want too much money, or perhaps even don't feel that they are qualified to earn as much money as you are offering for the position. The idea then follows that this should streamline your hiring process. Hopefully, you're cutting down on the number of people who are applying for the job that wouldn't end up being either qualified or interested in accepting the job at the compensation that is being offered. The motivating factor for all of these laws that are coming into place is the idea that disclosing pay ranges up front will help reduce discrimination and specifically eliminate pay inequality. So there are concerns that certain groups are systematically disadvantaged by pay secrecy, if that's the opposite of pay transparency. Specifically, women and individuals with disabilities or persons of color are thought to be perhaps disadvantaged in the compensation arena for various reasons that largely include either intentional or unintentional discrimination. For example, we will offer less money to this individual because they are a woman, not a man, or because they are black and not white, or based on certain notions of how likely individuals in different groups are to negotiate their compensation. Again, with the theory that men, for example, are more likely to negotiate their pay upward than are women for various reasons, and likewise, perhaps that certain other minority groups are more likely to just accept the pay that is given to them rather than seek a higher wage. So, another reason that employers may be choosing to post the pay scale for the jobs that they have available would be to demonstrate fairness or show that they are truthful, open, and honest. And these may be character traits that would appeal to potential employees as well. Flipping to the other side, some of the reasons why a company may not want to disclose how much they're going to pay for a position. Um, one of these is the simple privacy concern. If we disclose what we're paying for a particular position, then whoever gets hired for that position risks everyone knowing how much money they are making. Or, for example, you have a number of people in the same position. If you post what you are paying to new hires in that position, your incumbent employees in the similar position may then have their pay rate basically disclosed to the public. In certain situations, that may or may not be a large concern, but it's certainly a factor in some. The probably bigger concern for businesses generally is the potential for gripes and complaints from current employees if you post a certain position that's either the same as positions that are currently filled or at a level obviously just below or just above an incumbent position, then that pay rate that you are identifying in the posting gives a signal to that employee, perhaps either that they are getting paid too little or that they um, even may need to seek to negotiate a higher wage or question whether they should be in a different position, whether that be with your organization or another organization. There are a lot of factors go into compensation, including how long someone has been with a company. So, if you are, for example, posting for a new position that is comparable to an existing position, and the incumbent in that existing position has been there for a number of years, they may wonder why the relative difference in the pay rate does not comport to what they think is appropriate given their past service to the organization. These factors could likely, in some situations, lead to higher overall labor costs. If you have to disclose or you choose to disclose how much you're paying, you may have incentive to post a higher wage range, even if you're not going to necessarily pay at the top of that range for most hires. If that then leads incumbents to negotiate for higher wages and you want to retain them, then you're going to have to pay more. If you then factor in risks of discriminating between new hires and existing employees, then you may have to pay your new hires more as well. And that could lead to higher labor costs than if you did not have to disclose all of this information. Obviously, the proponents of the laws requiring these types of salary disclosures are not likely to be concerned about higher labor costs, but that doesn't mean that an individual business or industry generally wouldn't be concerned about that. It may be harder to set your compensation properly if you choose to or are required to disclose what the compensation is going to be up front. There are likely positions where you intentionally prefer to see what candidates you get and then even perhaps change the nature of the position based on who is hired, the experiences they bring, and that could yield a significant variation in what their compensation is going to be. We're going to need to feel more inclined to stick with it in most situations, and you will have the extra challenge of having to come up with compensation before you speak with any candidates for the position. Finally, among potentially other concerns, there's a risk by disclosing what you're paying for various positions that you reveal valuable business information to competitors. If you are disclosing what you are paying for positions that your competitors also need to fill, and especially if they're not likewise posting the wage information positions, then they could gain insight. So we were going to move in next to discussion of the legal requirements that have come into place, mostly in the last year or so across the United States. Thank you for letting me know you can hear me. And again, this information will be shared at the end, all the slides, and we can answer any questions. Yeah, if you had to log out and back in, I appreciate it. I'm not sure what happened, but it's a first in 20 or 30 of these presentations using the same platform. So states are currently in the process of bringing pay disclosure laws into being. There are, less than 10 states right now that have some form of pay disclosure requirements. Those are listed on the slide in front of you: California, Colorado, Connecticut, Maryland, Nevada, Rhode Island, and Washington all have some form of pay disclosure laws. In many of these states, the requirement is not that the pay rate be identified in the job posting, but that it be provided at some point early in the hiring process, such as in many cases, it has to be given at or after the initial interview, or at least when any job offer is made, or somewhere between the interview and the job offer when the applicant would request information about the salary range. So the laws do vary. Colorado, for example, is one instance where I believe the law does require that all job postings include a salary range, but most of the others are not going quite that far yet. So now the big question is, what is going on in New York? So just a couple of existing New York State laws that I wanted to mention. These come from New York's pay equity law or pay discrimination law, however you want to look at it. The salary history ban that took effect in 2020 prohibits employers from asking applicants about their wage or salary history. In other words, you're speaking to a candidate for the position, you can no longer ask them how much are you making at your current job, or how much did you make in your last position, for example. And if for some reason the employee provides or the applicant provides this information during the hiring process, employers cannot use that information in making their hiring decisions and determining wages. There is a situation allowed where the applicant wants to negotiate their salary higher, so they could identify how much they are making in a current position or have made in a previous job, and use that to seek additional money. But other than that exception, that information is not supposed to be part of the hiring process. And these protections generally apply to current existing employees too. For example, in the area of promotion and transfer consideration. There are a couple of different sources applicable to New York on um, employee protections to be able to discuss what they are paid in their job. So for a long time, Section 7 of the National Labor Relations Act has been interpreted to allow employees to discuss their compensation for their mutual aid or protection. The biggest implication of this is that, first of all, the National Labor Relations Act only applies to private sector workplaces, so non-governmental, non-public jobs. But in the private sector, it was not unusual, may not be entirely unusual still in some places, for companies to have a policy in their handbook, for example, that says you cannot tell other people how much you are paid. In most cases, federal labor law says that that is a violation of federal law. That doesn't mean that there aren't some employers out there who still do that, but that's available. There are some limitations on that beyond being only in the private sector. Employees under the National Labor Relations Act are only protected if they're non-supervisory employees. So there are some supervisors who theoretically you could tell them under the National Labor Relations Act that they cannot disclose how much they are paid. The other more recent legal regulation of this area in New York State is the Equal Pay Law, which says that employers cannot prohibit employees from inquiring about, discussing, or disclosing the wages of such employee or another employee. There is a limitation on this, for example, for human resources and payroll employees who have access to the information about compensation for a number of employees. They are not, or they can be prohibited anyway from disclosing that type of information generally. But the idea behind this state law protection is once an employee knows how much they are paying, you cannot stop them from talking about that with other employees, other than you can have reasonable restrictions on them talking about it when they're supposed to be working, just as you could under the National Labor Relations Act. So it's not to say that employees have an unfettered right to sit around the office all day talking about how much they get paid or why they're not paid more. But generally, you can't prohibit them from doing it, at least on their own time. So here comes the first big game changer in New York State, and that is in the form of the New York City Pay Transparency and Job Advertisements Law. I'm not sure that that is an official title, but that is at least what the New York City Commission on Human Rights is referring to it as. And real quick, before we get going into the details of this, I just want to throw up a quick poll that you can click to let us know whether your organization currently has employees working in New York City. I know we have people on from around the state of New York, so just thought it'd be interesting to see how many of you currently have employees in the city itself. Early returns are 100%. I don't expect 100% of you do. There we go. It does look like a large percentage of you have an employee or more working in New York City. Not entirely surprising. That might be what attracted you to listen in to today's webinar, because this new law is coming and will likely affect you going forward. However, it is quite likely that legal changes in New York are going to affect more of you than just those who currently have employees in New York City, as we will discuss shortly. Okay, so what is the New York City law? This was first enacted in January and then amended just a couple of weeks ago here in May of 2022. The amendment partially delayed the effective date of this law. So you now have until November 1st before these requirements come into place, but that is still less than half a year away. And some of you may already be preparing to comply. The requirement will apply generally to employers with 4 or more employees, even if only one of them works in New York City, and really even if only one of them works in New York State. So if you have one employee who works in New York City, even if, for example, they work remotely in their home, and you have 4 or more employees overall, then you are potentially covered by this law. You are covered, but you'd only have to satisfy it if you are going to do certain things that we are about to discuss. That is whether you are going to be making a job posting for a position that could be performed in New York City. This does include promotions and transfers, but only if you are somehow advertising the job. So if you have an internal employee who you are going to promote to another position, and you just decide internally to promote that person, you don't have to make some sort of written declaration of what the salary range is going to be. Even if you have several employees who are you're considering, and you bring them all in for interviews, and then you hire someone, if you have not posted it in some way, you've just contacted people and say, we want to speak to you, and then you choose one, then you don't have to disclose the information that you would have to disclose if you do make a job advertisement. And we'll get into that in more detail in just a moment. There is an exception as well for temporary help firms. So these are the staffing agencies who are just looking for workers to join their pool of temporary workers. I mean, in that situation, it's possible that the compensation the employees will receive is subject to what position they're ultimately placed in. The careful caveat here is, again, this is for businesses who are temporary help firms and seeking workers to join their pool. If you are one of these temporary agencies and you have your own, let's call them corporate employees, then you would still have to post the required information if you make job advertisements, say for your staffing managers. And then the flip side of this is, if you're not a staffing company, you're not a temporary help firm, and you're just seeking temporary workers and posting job advertisements for that in New York City, then you still would have to make the required disclosure. So real quick, what are we talking about when we talk about a job advertisement? This would be a written description of available job, including promotion or transfer opportunity, that is publicized to a pool of potential applicants, includes posting on internal bulletin boards, internet advertisements, printed flyers, and newspaper ads. So the traditional classified ad or any of the internet services that you post jobs on are going to qualify. And then again, remember, if the job could be performed in New York City, and you have at least one current employee in New York City and 4 employees overall, then you will have to comply with the law in the way that will be addressed momentarily. This is an increasing complexity with the possibility of remote work. So you might be a company that's based, for example, in Buffalo, New York. You are looking for an employee in New York State, and say you happen to currently have one employee who's a remote employee in New York City. That remote employee in New York City, and assuming you have 4 total employees, it means that you're covered by the law. And unless there's some particular reason why you would not be open to having a remote employee hired from New York City, you would be subject to this requirement. So it doesn't matter where your corporate offices are, your hiring managers are, etc. Do you have an employee in New York City, and could the job be performed by someone in New York City? Obviously, if you're hiring for an on-site position and you don't have any facilities in New York City, then you wouldn't have to comply. So assuming you do have to comply in your job postings, the law requires that you state the minimum and maximum salary or hourly wage for the position. When originally passed, the law talked about salaries, and there was a question of what happens for employees who aren't paid on a salary basis but are paid on an hourly basis. It's clear that the city was only looking to cover compensation, not to distinguish salary from hourly wage positions. So now any form of compensation theoretically has to be identified with a caveat that I'll mention. The range may extend from the lowest to highest salary wage or salary or wage the employer in good faith believes at the time of the posting it would pay for the job. Now, the only real clarification beyond saying it has to be a good faith belief is that you can't just say either the minimum or the maximum. You cannot say we will pay at least $50,000 a year, and you can't say we will pay up to $100,000 a year. There has to be a lower and upper range. Now, how large that range can be and what would be considered good faith is open ended and is subject to potentially future litigation over whether a given range was reasonable under the circumstances. So the law just requires the minimum salary or hourly wage and the maximum salary or hourly wage. There's no requirement to identify overtime rates or even whether overtime is applicable or any other forms of compensation or benefits. The one kind of gray area in my mind is a position that's entirely commission based. For example, is there a salary or hourly wage for such a position? If not, do you have to identify commissions in any way, shape, or form? Perhaps, and this is just speculation on my part, perhaps in that situation, you could say that compensation will be on a purely commission basis. That's keeping in mind whether you're able to do that in consideration of minimum wage requirements. There are certainly outside sales employees who are exempt from salary requirements for overtime, and that might qualify. But if they're not outside sales employees and they're being paid on a commission basis, theoretically, there would still have to be a backup minimum wage provision. So there are some gray areas, and potential whether they're loopholes or gotchas remains to be seen. But for most positions, the idea is, you know, $15 to $25 an hour or $50 to $65,000 per year or whatever the applicable range might be. On the enforcement of this New York City law, it's a little peculiar. Only current employees can bring a civil lawsuit against their employer alleging a violation, even though it seems most likely that for job postings, prospective employees are going to be more likely to be affected. That's not to say, however, that applicants don't have any recourse under this law because it is part of the New York City human rights law. So anyone who feels aggrieved by a violation of this new requirement can file a complaint with the New York City Commission on Human Rights. The restriction on civil lawsuits is only limited to current employees, is only limited to civil lawsuits. It's not limited and doesn't apply in the case of a complaint with the New York City Commission on Human Rights. Question whether that was intentional or not. I guess I'll just leave it at that. But that's the way the law is written now. The civil penalty for the first offense is capped at $0 if the employer cures the violation within 30 days. So if upon being made aware that they did not include a salary range, or that they didn't include a reasonable salary range in a job posting. In the first instance, the employer can somehow fix the violation within 30 days. Then there's no civil penalty for subsequent violations, or if the employer refuses to fix the violation, then there can be a civil penalty of up to $250,000 per violation. Again, what discretion the Commission on Human Rights will use in those cases remains to be seen. None of this necessarily, however, prevents an employee from making a complaint that they were aggrieved and suffered losses by the violation, in which case they may be able to obtain, for example, lost pay, damages, and there could be additional damages, and including fees, attorney's fees, and costs as well. All right, for those of you who are not in New York City, or most of your employees are not in New York City, etc., here is where you particularly want to start paying even more attention. Separate and apart from this New York City legislation that's set to take place in November 1st, there is a proposed bill at the New York State Legislature in Albany. And in preparing for this presentation, I, as recently as yesterday, checked on the status of this bill, and lo and behold, literally yesterday, the third reading of this proposed bill was made. It's out of committee, and it looks like this could go to a floor vote, up or down, potentially as early as next week, in which case it certainly seems plausible that the legislature will enact, or at least pass, this legislation. And I don't see a lot of reason to believe that the governor would veto it. All that by way of saying that it will not surprise me if within the next week, or otherwise sometime in June, New York State has passed and the governor has before her a law on pay transparency that would apply throughout the state of New York. I'll tell you right up front that the effective date in the proposed legislation is 270 days from enactment. So that's roughly 9 months, which suggests that we're probably looking at the spring of 2023 before this law would take effect. But again, it is possible that it will take effect by then. This law, believe it or not, is actually broader than the New York City law. I think it would be the broadest of these pay transparency laws to come into effect in any state so far. That doesn't really surprise me. New York State likes to be the leader in these employment protections. The one caveat here is, unlike the New York City law, the way this would come into the New York labor law currently means that it wouldn't apply to the public sector. So it would only apply to private non-governmental employers. So cities, towns, school districts, etc., might not be subject to this. The only reason I say might not is there is a separate bill in the legislature that would extend coverage of this portion of the labor law that includes a bunch of other things right now, that would extend that to the public sector, where they have traditionally been excluded. So that bill has not moved as far. So whether that's going to happen remains to be seen. That would have significant implications in other ways for public sector employers, but certainly is possible that it would be passed, in which case this could apply in the public sector as well. All right, so what does the proposed bill say? Well, first of all, it applies to all jobs, including promotions and transfers, that can or will be performed, at least in part, in the state of New York. There is a 4-employee requirement in the current bill, as there is in the New York City bill. But of course, that's statewide and not limited to New York City, that you have now at least 4 employees probably in New York State, not just one. But you have 4 employees in New York State and you apply or you are posting for any job that can or will be performed, at least in part, somewhere in New York State, you would be subject to this new law. And now we have additional disclosure components. If the job is advertised, the employer must disclose not only the compensation or range of compensation, but also a job description, if one exists, and a description of fringe benefits, bonuses, stock options, commissions, etc., if applicable. So rather than just the pay range, salary or wages, you now have to describe fringe benefits, including bonuses, stock options, commissions, other forms of pay. Likely, if it were passed with the current language, we would need the Department of Labor to come out and give us some regulations to explain the extent of that. I mean, do you have to absolutely identify the full bonus structure? And if so, do you have any flexibility with that down the road? But again, it's clear to see that this would be broader than the New York City requirement. The job description component is not necessarily as onerous if you are listing it on one of the online job sites where you have plenty of room usually to describe what the job is going to entail. But if you're using the more traditional classified ad where you're paying by the word or the line, putting an entire job description there obviously could be problematic. Okay, with that being said, I want to talk about some of the complicating factors in complying with these laws, both the New York City law that's coming and the New York State law that is potentially also coming. Plus, of course, the possibility that you also have employees in other states and or cities where there are similar requirements or similar requirements will be coming soon. The probably biggest problem in 2022 in face of these emerging requirements is the prevalence of remote positions. If nothing else, this means that you have employees in more locations because they're working from home, likely in some cases now without any expectation that they're ever going to be working in an office owned or controlled by their employer. And as you see with the New York City law, that is going to subject you to laws in those jurisdictions. And you may be subject to laws that include the possibility that someone could be hired to work from anywhere. So, especially if you're posting online jobs, it's not hard to post for the position as a company based in wherever, Albany, New York, for example. If you're open to remote employees, you might limit yourself to hiring people who are going to be working remotely in New York State, or you might open yourself up to people that are working anywhere in the United States, or you might even open yourself up to people working anywhere in the world. But in any of those situations, you may run into needing to comply with the pay transparency laws in those different jurisdictions. The other possibility is, even if that's not a problem for you, what do you do about comparable positions in different locations? If, for example, you have employees by chance working in Colorado and New York State, but not New York City at this point, the Colorado law may require you to post what you are paying for those positions as you're hiring in Colorado. and your employees in New York may be able to find out what you're paying for those positions in Colorado. And yes, perhaps the cost of living is higher in Denver, Colorado than it is in Rochester, New York, but that doesn't necessarily mean that your employees in Rochester, New York are going to be happy if they see that you're posting for the position in Denver and paying significantly more than you're paying in Rochester. Um, and of course, you may, in fact, be hiring for similar positions in different locations at the same time, in which case, you could have employees who decide, well, I'd rather work at this one location based on this other location based on the pay difference. Not to say that couldn't already happen, it's just that there's more clear information readily available to the applicants and your existing employees on those different factors. The other complexity, if you tie it back to the remote positions, is what happens if you have the ability to hire someone who works pretty much anywhere in the United States. Is the pay range going to be the same for someone who works in San Francisco as for someone who works in rural upstate New York? Um, Theoretically, it could be. And the fact that someone who lives in San Francisco might have higher costs of living chooses to accept the position doesn't mean you're willing to pay more. But then what happens if it turns out that all the really qualified individuals do happen to work in places where they demand higher compensation than your, office location and what you're used to paying? And then you've posted a job range. It's not entirely clear what happens if you then decide, well, we're going to pay more than what was in our posted wage scale. Is that in and of itself a violation? And does someone have a complaint to be made on that basis? Impact on the compensation of incumbents. Again, once you have to start posting how much you're paying for new hires in various positions, there's going to be more transparent information out there available to your existing employees. And let's be frank, there will likely be plenty of services out there that are aggregating this information and making it available either for free in some form or um, in exchange for payment, so that you can find out how much is company X posting that they're going to pay for various positions that they have. Your existing employees will gain access to this information inevitably and presumably use that in negotiating their own compensation in one shape or form or another. Finally, among probably many other complicating factors that one could imagine, is the issue of union organizing. So there seems to be a current rise in union organizing. I've looked at that in some detail, and whether there's an overall rise or literally, frankly, just the fact that every Starbucks location is organizing that accounts for the numbers right now. Either way, there's a sentiment of increased union organizing. One of the things unions like to do is say that we can get more pay for the employees if they join our union and let us negotiate with the employer. So they may be very interested in this wage information, especially if they can point to one company that is unionized and show that they're posting for higher pay than another company that is not unionized, and use that to try to unionize the lower paying company. Again, not to say that inherently good or bad one way or the other, but it is the reality that many businesses do not want to have to deal with a union organizing campaign or with negotiating over compensation with a union. And it's just at least plausible that unions could become active in utilizing this data that will become available. Finally, some compliance considerations before I get to the questions. what should you consider doing in your organization, either if you're in New York City and you're going to have to comply with the law that's coming there in November, or if the New York state law comes into effect, or if you're just currently employing people in other locations where they might have similar laws. The first thing that is probably advisable, although maybe not the first thing you do, is to consider an audit of your current compensation. Again, these laws are designed to identify and or eliminate pay inequality, and understanding where you may currently have some perception of inequality could go a long way in how you're going to approach setting your salary ranges, if you have to post them publicly. Obviously, if you identify some arguably um, inappropriate variations in compensation within your existing workforce, you may want to address those. You may want to then address those before you have to start publicly posting your salary ranges for certain positions. Conversely, if you just use this as a method of understanding what the ranges of pay we currently have for different positions really is, that may better enable you to identify what to put in the job posting for your salary range, and then have that information as justification for why you had a good faith belief that that was the right range. So again, that is another piece of the puzzle. You do have to determine some process for, I say here, objectively setting a good faith compensation range. Not that anyone would haphazardly set their compensation range in general, but the better process you have and the better you've defined how you set your compensation ranges, presumably the better chance you have of demonstrating that you have a good faith range identified in all of your job postings. So certainly there's different ways you can do this. You can rely on market surveys. You can base it on what your current wages are and considering factors like how easy or hard it's been for you to get applicants or to hire individuals at the wages you've currently been offered. If not, you presumably are going to be offering more going forward. Um, one interesting aspect of this, as I said, there's going to be more data available, presumably, about what people are paying for comparable positions. So you may ultimately need to obtain that data to set your own compensation. And therefore, that will affect what your ranges are. There is an ironic aspect of this. I mean, antitrust laws currently create barriers to companies getting together and sharing information about how much they pay, um, out of fear that it could keep pay rates down. So the fact that companies can't do it on their own, but it's going to be done for them as a result of these disclosure requirements, presumably is going to shield the companies from antitrust violations, because they're not going to be working together. They're just going to be working now with publicly available information. But I don't think there's a guarantee that wage rates are going to go up as a result of this. It is possible that the information will enable businesses, at least in certain industries, to collectively keep wages at potentially lower levels. So that would be interesting to track going forward, but leave that to some economists. Obviously, you'll have to review job postings as compensation rates change. You can't just run back out the same job posting every time if there is an increase in minimum wage and the job is somewhere down in that range. You wouldn't want to post a job where the range still says the lower wage possibility is lower than what the current minimum wage is. Presumably, you wouldn't then pay lower than minimum wage anyway, but I think it would be hard to argue there was a good faith compensation range if it was suggesting you would pay less than minimum wage. So be careful to keep those current. And the final consideration I offer at this point is to evaluate alternatives to advertising openings in compensation sensitive positions. Not every company that's hiring for a CEO is likely to make a public job posting for the CEO position. But I think it's fair to assume that most companies would feel it limiting to have to identify a good faith salary range for their CEO before that person is brought in. But there are alternatives. You can work with recruiters and headhunters to bring in candidates. And again, as long as you haven't made some sort of public or internal posting that you're looking for that position, talking to people and trying to find candidates and bring them in doesn't necessarily run afoul of the the new requirement in New York City and the one that may be coming in New York State and elsewhere. On the other hand, not publicly posting may limit the range of candidates in a way that might lead towards appearances of discrimination or favoritism or nepotism and those types of things. So there might be a trade off there. But again, you do have that option to consider whether you want to avoid posting a certain position because you don't want to have to reveal the salary range, or possibly because even if you wanted to, you just aren't comfortable that you could come up with a good faith compensation range before starting to begin the hiring process. So now in a moment, I'm going to post the link to the slides. I appreciate all of you who've stayed on. Sorry about our technical glitch earlier in the presentation. You will get an email tomorrow with the slides as well. As I mentioned, it could be soon that we see a law from New York State that comes out, even if it won't take effect till next year. Once that comes out, that's the type of thing we would certainly post information about on our LinkedIn page and the website, which is hortonpllc.com. But the fastest way to get information that we become aware of that might be of interest to employers is through our LinkedIn page. So Horton Law PLLC on LinkedIn. So I'm going to go back. I know there's a couple of questions, or at least one question already in. If you have any other questions, go ahead and start typing those in, and I'm going to put up the link to the materials. Okay, so one question we had is if the New York State law passes, would New York City scrap its new law? We had a similar thing happen with the New York City sick leave law, as you may be familiar with. They probably would not scrap it. You would probably technically be subject to both if you're hiring for positions in New York City. That being said, in New York City, you would have to then comply with both, not just the New York City law. And as currently drafted, it looks like the New York State law would be broader than the New York City law in most cases. Because it would require identifying additional information. There may be slight coverage issues. As I said, arguably the New York State law only applies if you have at least 4 employees in New York State, where the New York City law arguably applies even if you only have 1 employee in New York State, if that person happens to be in New York City and you have over 4 employees overall. So those the other thing, as we saw with the sick leave law, is if need be, the New York City Council or the Commission on Human Rights may somehow adapt how they're enforcing or what the requirements are of the New York City law to make sure that compliance with the New York State law would also apply to New York City for people who are subject to both. Right, so that was the only question I think that I had so far. If there's any other questions, please go ahead and start typing those in, or at least let me know that you have a question if it's going to take you longer to type it in. want to check one thing because there was a comment about the New York state law addressing commissioned folks. It does. I'm just trying to see what the exact wording was, but just give me 1 second on that if you're interested. If not, thank you for joining. You can certainly log off at your convenience. I appreciate your time and hope you will attend future webinars. But if you have any other questions, go ahead and type those in. And in the meantime, I'm just looking up that one point about the commission-based employees. Yeah. Okay. So the clarification there is if it's a commission-based job, that the disclosure just needs to be that the compensation will be based on commission. So thanks for pointing that out. I just want to double check that. So you don't necessarily have to explain the whole commission process. But again, if it's not a purely commission-based job, you'd have to post the salary minimum and maximum, and then also post information about commissions. So whether that means, again, that just a notion that you state that there's also the possibility to earn commissions, or you have to somehow specify that in more detail, remains to be seen. Okay, well, I thank everyone for your time. And with that, we are going to log off, and I just hope to see you next time.